Federico, good morning to everybody. As Professor Bellingeri has already indicated and Federico has explained, we have in the Italian legislation a number of problems arising from one hand, the lack of ratification or accession, more precisely, of the LLMC Convention, from one hand, and the adoption of the EU Directive on Insurance in the way it has been done. But where I would like to start from is a statement which is contained in the preamble to the European Directive 2009-20, which is the directive of which the legislative decree 111 intends to be an implementation under Italian law. States, the members of the EU community, are reminded of their recognition of the importance to ratify the Limitation of Liability Convention. And this is the origin of many problems, the origin of the problems for Italy who did not ratify the convention, because the European legislation, regulations, directive, are based on the assumption that all member states are party to the convention. But since Italy is not, Italy is continuing to incorporate legislation which is based on this assumption without being party, and the problems are those which have been described, and I will add some other examples. One of the purposes of conventions is uniformity. Through the adoption of a common regime applicable to certain aspects, conventions make this regime applicable in all member states in the same way. And this, for instance, in the LLMC Convention, is achieved through the scope of application as described at Article 15, which binds the judges of all states party to the Convention to apply the provisions of the Convention on limitation of liability. The adoption of the Convention would have solved one of the problems of Italian law. In fact, according to Italian law, Article 7 of the Code of Navigation, the law of the flag is the law which governs limitation. And far from applying a uniform regime, Italian courts have and are continuing to apply a different limitation regime, limitation law, case by case, depending upon the flag of the ship involved. As I said, the adoption of the LLMC Convention would have helped to solve this problem. Instead, the solution adopted by the Italian legislature as to the identification of the scope of application of the decree, of the legislative decree, is this one. Reference is done as a condition for the application of the legislative decree to the flag, Italian flag, and to other flags when the ships enter into Italian ports or transit through the Italian territorial waters. I must say that not only the choice of the Italian legislation not to ratify the LLMC Convention is not a proper one, because we missed the opportunity to solve the problem of the identification of the applicable law, but also we are adding confusion through this. What is meant for transiting through the Italian territorial waters as a criterion for applying the legislative decree and the limitation? Transit when the accident to which the limitation refers to, transit at an earlier stage, transit at a later stage when, for instance, limitation proceedings are brought. Is it sufficient that the vessel transits through the Italian territorial waters once, and for the rest of the life of the vessel, this legislation would apply? My view, based on the fact that Article 3 of the legislative decree is no more than a transposition in Italian law of the provisions on scope of application contained in the Directive of Insurance, which makes reference to ships entering into ports or possibly ships transiting in territorial waters is that the scope of application, as described in Article 3, applies just to the insurance provisions of the legislative decree, and for the rest, we continue to have Article 7 applicable to limitation then, and we will continue to have the lack of uniformity created by the reference to the law of the flag. At the beginning of my presentation, I made a short reference to uniformity. Another aspect regarding uniformity, which the LLMC Convention would grant, is the definition of the parties entitled to limit, which is contained at the second paragraph of Article 1, where shipowner is described as including not only the owner, but also charterer, manager, and operators, generally speaking, of a seagoing ship, as parties entitled to limit. This is, again, quite different from the Italian law system, where I refer again to Article 7, reference is made just to the owner. For owner here, we mean the armatore in Italian, which includes not only the registered owner, but also the bareboat charter, the demise charter. And these provisions originated a lot of problems so far. For instance, Italian courts would not recognize in Italy a judgment of a foreign court confirming title of a charter to limit, because Italian law just contemplates the owner's title to limit. And again, the possibility given by the LLMC to overcome this problem and make Italian law similar to all other countries has been missed in the legislative decree, where, and it is not even attempted to help, a reference is done to an armatore whose description, here it is in English, and it is again a sort of translation of the wording of Article 3, paragraph A of the directive. The definition of shipowner for the purpose of insurance is very similar to the definition of shipowner as per Article 7, which includes just the registered owner and the bareboat charter. The effect, however, is that the legislative decree provides for limits of liability of shipowners described in this way, not the charterers, not the managers, not, generally speaking, the operators. There are many other Italian laws which are somehow affected by the lack of ratification of the LLMC Convention. One is what we call the Codice dell'Ambiente, the Code of Environment, which incorporates all Italian law provisions regarding environment. Part 6 of the Code of the Environment is dedicated to the damage to the environment liabilities, and also includes this provision, which says that the provisions contained in the Part 6 of the Code of the Environment are without prejudice. This is the English version. This is the directive of which Part 6 intends to be an implementation. So the Code of Environment, as the directive, the provisions on liability are without prejudice to the right of the operator to limit liability in accordance with the LLMC Convention, which is very strange for an Italian law, because Italy is not a party to this convention, which is referred to in the Code of Environment. And this Part 6 of the Code of Environment refers to, by definition, to damage, includes damage to seawaters caused by ships in cases which are not covered by the CLC. So it has a practical application. And one may wonder what it would happen if an Italian ship pollutes and is subject, the owner is subject to the provisions of the Code of the Environment, whilst the title to limitation is referred to a legislation which is not part of Italian law. We may have problem of conformity with Constitution, as those Professor Berlingeri has mentioned, generally speaking, with respect to the legislative decree. I will conclude with an additional comment on the various strange effects of the Code of Environment and lack of ratification of the LLMC. The party which, according to the Code of Environment, can be responsible and can limit in accordance with the LLMNC is an operator. And this is the description of the operator definition, which matches with the definition of shipowner under the LLMNC, which means that according to the Code of Environment, charterers, managers, operators, and shipowners can be liable, but under Italian law, due to the lack of ratification, only the owner can limit. And this is a very serious problem which I would like not to have the occasion to deal with, provided my recommendation conclusion is accepted. Italy must complete the process for the accession to the LLMNC Convention. Thank you.